Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back with the second video on the Securities Contract Regulation Act 1956. We have already done our first lecture on this act and today is our second lecture. So we are done with the SEBI Act, the Depositories Act, and today we will be finishing the Securities Contract Regulation Act 1956, right? So I have been stressing on this point very much that security laws, they carry 40% weightage for your examination. They are very important, they are very crucial, so please make sure that you are studying these security laws very carefully, right? These will be very important for your examination. You cannot leave them. You have to study each and every act, you have to study each and every regulation, right? Before I begin, I would like to tell you that EduTap has come up with two courses for phase 2. The first is the test series and the other one is the live crash course. For your phase 2 examination, for the preparation of phase 2, it is going to be very helpful. If I talk about the features of test series, you get chapter wise test. So chapter wise test means you get tests, that means questions from each chapter. For example, from IPC, every chapter for IPC that is coming into your syllabus, and same goes for the company laws and same goes for the security laws. So you get questions from each of such chapters, right? So they have been divided, the questions, they have been divided according to the chapters. So it is going to be very helpful for your preparation. When you complete one chapter, you can refer to these questions and you can evaluate yourself, right? The second one is full length test. The full length test also includes the descriptive part. This time, as you already know, that descriptive part, it has been introduced by SEBI. So we are focusing on descriptive part as well. For your full length test, you get the evaluation. So the experts will be evaluating your test. So you will be getting feedback on your descriptive part also. And you also get one-on-one mentor support. And for the live crash course, all the features that I have mentioned for the test series, that is the chapter wise test, the full length test plus with evaluation and the one-on-one mentor support, they are all available in the live crash course. But there are two more things that you get. Those are first the live classes. You will be getting live classes. You will be getting live class on each and every subject that is part of your syllabus, right? And also you get short notes that will be helpful for you to prepare for the descriptive part this time. So if anyone of you wants to avail this offer, can refer to the link in the description below. So now let's start with this lecture. Question number 1. Which of the below is our incorrect information relating to the depository? We have done what is a depository. So which of these is incorrect? NSDL and CSDL have designated various depository participants on its behalf. Depository participants open demat account for investors. Depository participants can be bankers or the brokers itself or none of the above. So the answer is none of the above. That is, all these statements, they are correct with regard to the depository and the depository participants. NSDL and CSDL, they are the only depositories in India and they have designated various depository participants on their behalf. Depository participants, they help to open the demat account to the investors, and depository participants, they can be banks on the brokers itself. Depository participants can be bankers or brokers itself. Alright, question number 2. Under which section of the Securities Contract Regulation Act 1956 the central government can delegate all powers to the SEBI? So the answer to this question is C, that is 29A. So under section 29A, the central government, it can delegate its powers to who? It can delegate its powers to the SEBI, that is the Securities and Exchange Board of India. Let's read this section. This is section 29A. The central government may by order published in the official gazette direct that the powers, except the powers of section 30, right? So except the powers of section 30, they can transfer their powers to SEBI exercisable by it under any provision of this act shall in relation to such matters and subject to such conditions, if any, as may be specified in the order. It can be subject to any condition as it will be specified in the order. Be exercisable also by the Securities and Exchange Board of India. That means in addition to the central government, they can also exercise it, or the Reserve Bank of India constituted under the section 3 of Reserve Bank of India Act 1934. So it can do it to the SEBI and the Reserve Bank of India. And section 30, that was the exception in this case. Section 30 is an exception to this section which deals with the powers of the central government to make rules. Alright. Question number 3. As per Section 21A of the Securities Contract Regulation Act 1956, which of the following can delist the security? So, who has the power to delist the securities? The answer to this is option C, that is the stock exchange. Under Section 21A, a recognized stock exchange may delist the securities after recording the reasons therefor from any recognized stock exchange on any of the grounds or grounds as may be prescribed under this act. So, who has this power? A recognized stock exchange. It can delist the securities, but it has to record the reasons that why it is doing so. There is also a proviso that the securities of a company shall not be delisted unless the company concerned it has been given a reasonable opportunity of being heard. So, the company's side is also to be heard before delisting their securities. A listed company or an aggrieved investor may file an appeal before the Securities Appellate Tribunal against the decision of the recognized stock exchange delisting the securities within 15 days from the date of the decision of the recognized stock exchange delisting the securities, and the provisions of Section 22B to 22E of this Act shall apply as far as may be to such appeals. So, the listed company or any investor, any aggrieved investor, they can prefer an appeal before the SAT, that is the Securities Appellate Tribunal, within 15 days. It has to be within 15 days against any such order of delisting the securities, right? So, a listed company or an aggrieved investor may file an appeal before the Securities Appellate Tribunal against the decision of the recognized stock exchange delisting the securities within 15 days from the date of the decision of the recognized stock exchange delisting the securities, and the provisions of 22B to 22E, they shall apply, provided that the Securities Appellate Tribunal may, if it is satisfied that the company was prevented by sufficient cause from filing an appeal within the said period, allow it to be filed within a further period not exceeding 1 month. So, a relaxation period of 1 month can be given if it was satisfied, if it is satisfied that they were prevented by a sufficient cause of action. Alright. Question number 4. Any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to which of the following authority? The answer is E, that is the Supreme Court, right? This is under Section 22F. Any person aggrieved by any decision or order by the Securities Appellate Tribunal may file an appeal to the Supreme Court. So, they can file an appeal to the Supreme Court, and the period of limitation is 60 days from the date either of the communication of the decision or from the date of the order of the Securities Appellate Tribunal to him on any question of law arising out of such order. But it has to be on a question of law. This we have covered, provided that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 60 days. So, a relaxation period can be provided by the Supreme Court, and it can be of 60 days, right? So, they can prefer an appeal before the Supreme Court against any decision of the SAT, and it has to be within 60 days either from the communication of the decision or either from the date of the order. Alright, question number 5. As per Section 23J of the Securities Contract Regulation Act 1956, which of the following factors have to be taken into account while adjudicating the quantum of penalty? This same question we also did in the Depositories Act. I hope you remember that. So, this is answer E, that is all of these factors they have to kept in mind. So, Section 23J, while adjudicating the quantum of penalty, under Section 12A or Section 23I, the Securities and Exchange Board of India or the adjudicating officer shall have due regard to the following factors, namely, so all these factors they have to be considered, which are amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of that default. So, any such advantage or if any such gain it has been made wherever quantifiable, it has to be considered. The amount of loss caused to an investor or group of investors as a result of default, and the last one, the repetitive nature of the default. Explanation: for the removal of doubts, it is clarified that the power of the adjudicating officer to adjudge the quantum of penalty under Section 23A to 23C shall be and shall always be deemed to have exercised under the provisions of this section. Question number 6. Section 7 of the Securities Contract Regulation Act 1956 deals which of the following? So it deals in E, that is the annual reports to be furnished to the central government by the stock exchange. So the stock exchange, they have to furnish the annual reports to the central government. Section 7 deals with the annual reports to be furnished. Every recognized stock exchange shall furnish the central government with a copy of the annual report, and such annual reports shall contain such particulars as may be prescribed. So they have to furnish annual reports to the central government. Question number 7. As per Section 16 of the Securities Contract Regulation Act 1956, which of the following has the power to prohibit contracts to prevent undesirable speculations in specified securities? So the answer to this question is C, that is the central government, right? So the powers to prohibit the contracts in certain cases, it is under Section 16. If the central government is of the opinion that it is necessary to prevent undesirable speculation in specified securities in any state or any area, it may, by notification in the official gazette, declare that no person in the state or the area specified in the notification shall, save with the permission of the central government, enter into any contract for the sale or purchase of any security specified in the notification, except to the extent and manner, if any, specified therein. So the central government, it can declare that no person in that state or in that area, he is going to enter into such contracts of sale and purchase as related to the such securities as have been mentioned in that notification. And the second one is all contracts in contravention to this provision, and if someone does that, so in contravention enters into after the date of notification issued thereunder shall be illegal. And if someone contravenes with this provision, they are the contracts, they will be considered what? They will be considered illegal. Question number 8. SEBI can issue directions if an inquiry reveals that it is necessary in the interest of investors or to manage the affairs of the stock market intermediaries is better way. Such directions can be issued to any stock exchange or clearing corporation, to any agency or intermediary associated with the stock exchange, to companies whose securities are listed on the stock exchange, or the companies where the securities are proposed to be listed on the stock exchange. So the answer is E, that is all of the above. So SEBI can issue direction to all of these, right? So SEBI can issue directions under Section 12A. It is Section 12A if after an inquiry reveals that it is necessary in the interest of the investors and or to manage the affairs of the stock exchange or clearing corporation or any other agency intermediary. The directions can be issued to who? To any stock exchange or clearing corporation, to any agency or intermediary associated with the stock exchange, or to companies whose securities are listed or proposed to be listed on the stock exchange. Question number 9. Which of the following is incorrect with regard to the delisting of securities? The first one is the securities of the company shall not be delisted unless the company concerned has been given a reasonable opportunity of being heard. A listed company or an aggrieved investor may file an appeal against the decision of the recognized stock exchange delisting the securities within 15 days. An appeal against the decision of the recognized stock exchange has to be made before SEBI. If appellate authority is satisfied that the company was prevented by sufficient cause for filing the appeal within the said period, allow it to be filed within a further period of not exceeding 1 month, or none of the above. So the answer to this question is C, that an appeal against the decision of the recognized stock exchange has to be made before SEBI. No, it has to be made before the Securities and Appellate Tribunal. Right, this we have already discussed in one of the previous questions. So an appeal against the decision of the recognized stock exchange, it has to be made before the SAT. So it is under Section 21A. All of these statements, they are correct, but the C statement it was incorrect, that appeal lies before SEBI. No, it does not lie before SEBI. It lies where? It lies before the SAT, that is the Securities and Appellate Tribunal. Alright, question number 10. Which of the following has the power to supersede governing body of a recognized stock exchange? So the power of supersession, it is with D, that is the central government. This also we have done, that supersede means to replace, right? So it can be done by the central government. It is given under Section 11. without prejudice to any other powers vested in the central government under this act, where the central government is of the opinion that the governing body of any recognized stock exchange should be superseded. Notwithstanding anything contained in any other law for the time being in force, in the central government may serve on the governing body a written notice that the central government is considering the supersession of the governing body for the reasons specified in the notice, and after giving an opportunity to the governing body to be heard in the matter, it may by notification in the official gazette declare that the governing body of such stock exchange to be superseded, and may appoint any person or persons to exercise and perform all the powers and duties of the governing body, and where more persons than one are appointed, may appoint one of such persons to be the chairman and another to be the vice chairman thereof. So the central government has to serve a notice to the governing body that they are considering their supersession, and they have to mention the reasons. And after the governing body, it has been given an opportunity of being heard. It has to be provided with an opportunity of being heard. And after it has been provided with such opportunity, it may by notification in the official gazette, the central government can by the notification in the official gazette declare that such governing body of such stock exchange is superseded. And to replace that governing body, they can appoint one or more persons for the working of that governing body, right, to perform all the powers and duties of the governing body. And where there are more than one person that have been appointed, out of those persons, one will be appointed as the chairman and another one will be appointed as a vice chairman, right. All powers and duties of the governing body, and where more persons than one are appointed, may appoint one of such person to be chairman and another to be vice chairman thereof. On the publication of the notification on the official gazette under subsection 1, the following consequences shall ensue, namely. So what are going to be the consequences of such supersession? The members of the governing body which has been superseded shall, as from the date of the notification of the supersession, cease to hold the office. So the members of the governing body, they will cease to have that membership from the date of the supersession. B. The person or persons appointed under subsection 1 may exercise and perform all the powers and duties of the governing body which has been superseded. So they will be carrying all their powers. And the third one is all such property of the recognized stock exchange as the person or the persons appointed under subsection 1 may by order in writing specify in this behalf as being necessary for the purpose of enabling him or them to carry on any business of the stock exchange shall vest in such person or persons. Alright, question number 11. Which section of the Securities Contract Regulation Act 1956 deals in the right of appeal against the refusal of stock exchange to list securities of public companies? The answer to this question is B, that is section 22. So section 22, it deals with the rights of the appeal against the refusal of the stock exchange to list securities of a public company, right? Let's read this section. Where a recognized stock exchange acting in pursuance of any power given to it by the bylaws refuses to list the securities of the public company or collective investment scheme, the company or the scheme shall be entitled to be furnished with reasons for such refusal and may. So they have to be given reasons that why they have refused to list their securities within 15 days from the date on which the reasons for such refusals are furnished to it. So it has to be within 15 days. Where the stock exchange has omitted or failed to dispose of within the time specified in subsection 1 of section 73 of the Companies Act 1956, the application for the permission for the shares or the debentures to be dealt with on the stock exchange within 15 days from the date of expiry of the specified time or within such period not exceeding 1 month as the central government may on sufficient cause being shown allow. Appeal to the central government against such refusal, omission or failure as the case may be, and thereupon the central government may, after giving the stock exchange an opportunity of being heard. So what the central government will do, vary or set aside the decision of the stock exchange. Either it can set aside the decision of the stock exchange, or where the stock Stock Exchange has omitted or failed to dispose of the application within the time specified granted to refuse the permission, and where the central government has set aside the decision of the recognized stock exchange or grant of the permission, the stock exchange shall act in conformity with the orders of the central government, provided that no appeal shall be preferred against the refusal, omission or failure, as the case may be, under this section on and after the commencement of the Securities Law Amendment Act 1999. Question number 12. Recognized stock exchange can make rules in which of the following matters? So the answer is E, that is all of the above. This is under section 7A. A recognized stock exchange may make rules or amend any rules made by it to provide for all or any of the following matters, namely the restrictions of voting right to the members only in respect of any matter placed before the stock exchange at any meeting, the regulation of voting rights in respect of any matter placed before the stock exchange at any meeting so that each member may be entitled to have one vote only, irrespective of his share of the paid up equity capital of the stock exchange. The restriction on the right of a member to appoint another person as his proxy to attend and vote at a meeting of stock exchange, or such incidental or consequential and supplementary matters as may be necessary to give effect to any of the matters specified in A, B and C. So, a recognized stock exchange, it may make rules or amend rules relating to any of such matters. Question number 13. No rules of recognized stock exchange made or amended in relation to any matter referred to in clause A 2D of subsection 1 shall have effect until they have been approved by the central government. But these rules, they have to be given approval by the central government, approved by the central government and published by the government in the official gazette. And in approving the rules so made, so amended, the central government may make rules, modifications therein as it thinks fit, and the central government can also make modifications, and on such publication the rules as approved by the central government shall be deemed to have been validly made, notwithstanding anything to the contrary contained in the Companies Act 1956. Question number 14. Every recognized stock exchange in respect of which of the scheme for compensation or demutualization has been approved shall either by fresh issue of equity share to the public or in any other manner as may be specified by the regulations ensure that at least dash of its equity share capital is held within dash from the day of publication of order by the public other than shareholders having trading rights. So the answer to this question is D. So this is section 4B clause 8. Every recognized stock exchange in respect of which the scheme for compensation or demutualization has been approved under subsection 2 shall by fresh issue of equity shares to the public or in any other manner as may be specified by the regulations made by the Securities and Exchange Board of India ensure that at least 51% of the equity share capital is held and within 12 months from the date of publication of the order under subsection 7 by the public other than the shareholders having trading rights, provided that the Securities and Exchange Board of India may on sufficient cause being shown to it and in the public interest extend the said period by another 12 months. So they can extend it for another 12 months. Question number 15. Appeal filed to the Securities Appellate Tribunal under Section 22A of the Securities Contract Regulation Act 1956 against the refusal of stock exchange to list securities of companies shall be endeavoured to be disposed of within what period from the date of the receipt of the appeal? So the answer to this question is within 6 months, right? So according to section 22A4, the appeal filed before the Securities Appellate Tribunal under subsection 1 shall be dealt with it by it as expeditiously as possible and endeavour shall be made by it to dispose of the appeal finally within 6 months from the date of the receipt of the appeal. So it has to be made within 6 months. The answer is option D. Now question for achievers. No member of the recognized stock exchange shall in respect of any securities enter into any contract as a principal with any person other than a member of the recognized stock exchange unless he has secured the consent or authority of such person, he discloses in the note, memorandum or agreement of sale or purchase that he is acting as a principal, he has secured the consent or authority by the SEBI, or he has secured the consent or authority from the central government, or only A and B. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.